justice and care. And please come and take your seat in the panel. Mr. Adrian Phillip is an advocate whose association with human rights field has spanned more than 15 years. Currently, he, as a director legal, he heads and supervises a team of 22 legal advocates and interns and partners of governmental and other non-governmental organizations on several projects. Adrian went on to complete Masters of Criminology and Environmental Law. During the course of last few years, Adrian has assisted the state with public prosecution on numerous occasions. He has been represented the CBI in the Bombay High Court as a part of his endeavor to address the gaps in criminal system. He has trained public prosecutors, magistrate, session judges. He has also been invited to train in police academics and judicial academics, besides training other law enforcement officers on different occasions. Can we just join our hands? Welcome Mr. Adrian Phillip. I would next call upon to join in the panel Mr. Subir Roy. Mr. Subir Roy is an Indian social activist. He has been working on anti-human trafficking for the last 10 years. His efforts to combat human trafficking has been recognized nationally as well as internationally. He was a journalist by profession, and his interaction with many survivors and situations motivated him to be a part of the anti-human trafficking movement. Mr. Roy has been involved in various research studies on anti-trafficking and was a part of India Country Assessment Report 2013, supported by UNODC. His legal knowledge about anti-trafficking is worth mention. He has worked in close coordination with many government organizations and law enforcement and other civil societies. Can we please join our hands welcoming Subir? Ms. Manisha Banaswani, currently working in the position of faculty associate at KEET Law School, KEET University, Bhubaneswar. She has completed her graduation in LLB from Utkal University and a post-graduation from Gujarat National Law University with specialization in intellectual property laws. She has enrolled as a PhD scholar in KEET in 2017. Apart from her academic, she is a professional Odissi dancer. Can we just join our hands welcoming Manisha? We would welcome Ms. Aishwarya Dev. She is a BLLB Honours Graduate from Department of Law, University of Calcutta. She is at present an LLM student at Nalsa, University of Law, Hyderabad, and is also pursuing PG Diploma in International Humanitarian Law from the same institution. Welcome her. We'll welcome Ms. Parvati Mohan, who hails from Kerala. Currently, she is a third-year LLB student in Government Law College, Mumbai, and graduated in BA Economics from Marivonius College, Kerala, Trivandrum. She has worked with Kerala State Women's Commission and also with Praja Foundation, Mumbai. Can we please welcome her? Thank you for being with us, and I wish that it will be a fruitful session. Thank you. About the moderator. No, I can hear.
I can be heard, I think. Good afternoon, everybody. It gives me enormous pleasure to be a part of this great two-day conference. And we won't waste much time. We have 5 speakers lined up, and all of them would be addressing certain socio-legal perspectives of anti-trafficking laws in India and in the global context. Through the 2 days, we've known, and through our works with which all of us are associated, we do know that perhaps the dearth of law is not a problem in the Indian context. It's more about how the law is not being implemented is of course one, or how the law is, what are the challenges that are posed before the law. Also, we know that there are several amendments that have been doing the rounds, but it is about coming to certain kinds of conclusive ends that we have not been able to achieve. We know about the debates around trafficking issues, around sex work, etc. in India and in the global context. And I'm sure that all the speakers here from a plethora of places and bringing in backgrounds of different kinds of backgrounds would be able to share their perspectives on the law and how it works in this context or how it doesn't work. With that, I would request our first speaker, Adrian Philip, to take over. May I request the speakers to keep their speeches or presentations short, is around for about 12 minutes, if that's so. And after that, I'll just give you around a couple of minutes and maybe, because I think we need to wrap in by about 3:15 because there's a next session. So if you could make your first initial points in about 10 to 12 minutes, and after that, I'm sure there'll be a round of discussion. So without further ado, may I now request Adrian to
You
want to take this?
No, if you take that chair.
Yeah, sure. Oh, yeah. Oh, I'm so sorry.
Good afternoon, ladies and gentlemen. Thank you very much for the opportunity to be here and to be able to present to you. It's an illustrious gathering here, and I've got some of my mentors sitting here in front of me. People I've worked with and have learned from over the years, and it's in that sense a huge privilege to be here today. About 5 years ago, one of my colleagues who works undercover came to me and told me, Adrian, nowadays criminal networks have completely understood us. And I asked him why. What is it that he was seeing in criminal networks that made him come up with a statement like that? And he told me that, I recently went down into one of these brothels and I was talking to one of those guys. He didn't know who I was. And he decided to tell me a little bit more than he would otherwise tell others. So he told him about how these NGOs today were coming in, totally sophisticated NGOs with spy cameras, and they have these little cameras hidden over or pens and watches, and he's saying that guy actually began to pat me down. So he said, just because I knew him relatively well and he was patting me down fine, but he didn't check further, because if he had checked, he would have found my little box, because I was wearing a camera too. What that meant for him was that his life would have been on the line if he was found out. So 5 years ago, criminal networks began to understand the technology and how it was being used as a means of investigation, as a means of prosecution, and so on. Our criminal justice system also began to be aware of this technology and how it could be used to. 5 years later, criminal networks have evolved. They have in place mechanisms to check, ensure that people are not coming in with cameras anymore. You can't have your phones into a brothel. They keep them all out. They pat you down. They check every which way they can. Today they're using WhatsApp to show images, to transfer data, to get information across. But our criminal justice system is still where it was 5 years ago. We're just beginning to bring that change. Only in 2015, the state has begun to accept human trafficking as organized crime. And then came the modification of the JJ rules, the new, hopefully, human trafficking bill, and so on. Only now are we beginning to use technology in the forum that we can use it. Our use, therefore, that addresses criminal networks is going to change. In the old days, we understood criminal networks as a big boss, the Don, and everything flowed from him. And that's how the system works. Globally, studies show you an entirely different picture. Criminal networks are now these small little budding organizations being connected to each other by very fluid means. Often these are through kinship or financial transactions. If we are to address human trafficking, if the criminal justice system is going to deal with this, then it has to come up with very innovative ways. It can't be dealing with prosecutions involving criminal networks that perceive criminal networks as a dawn and everything flowing from them. What are the solutions that the system offers that allows for things like this? One of those possible solutions that I'd like to talk about today is the use of technology. And how we can use technology to address this. So today, we are moving on to use the resources at our disposal. The law itself allows for video conferencing. The law itself allows for evidence in the form of videos or audio recordings. It allows for CDR copies to trace phone conversations. The law itself allows for technology to come into play. How many cases do we have on board? Technology. I thought that with investigations, we should bring to the forefront a whole series of different ways we can actually use things. I thought I'd highlight to you one of the last ones, which is artificial intelligence now. This is finding its way into every single aspect of our work. I know that in the seminar held earlier, yesterday morning, they spoke about technology and how one brings it into play in the whole realm of cybercrime. But technology like artificial intelligence comes into play in other crimes as well. So in human trafficking, for instance, we are now grappling with how we can use artificial intelligence to predict vulnerability, to be able to showcase how a victim affected by trauma will testify in a trial. It's something we hope will come up in the not so near future. In forensic technology, it's hard enough in human trafficking cases to get the police to pick up the right evidence. It's hard enough to get them to pick up used condoms, to get them to pick up fingerprints, to get them to pick up medicines that are being used to inject victims to make them appear older or younger than they are. But then to process this evidence is a major challenge. Any police officer in Kolkata will tell you that it takes 3 years to get a report back. In other places, perhaps it's a little quicker. In 2015, the Honorable Minister for Women and Child made a statement at the CIVAC meeting there where she said that we are going to have forensic labs across this country that will deal with only women and children issues. That's going to be some time coming. But let's use forensics. It's definitely possible. We can bring this through electronic evidence. We can bring this through financial transactions and evidence generated out of that. We can bring it through dismantling a computer today or a phone. And that's easily one of those ways of bringing technology to address the challenges of our times. Criminal networks today are not connected to the crime. There is no direct or material evidence which links them to what is happening on the ground. So, one of the only issues that we have for victims is for them to testify. There is no other way to get that conviction. If we move, therefore, to the realm of technology, if we're able to bring this other evidence on board, legal justice system will work differently. A few days ago, last weekend, in Maharashtra, we were looking to launch an SOP on video conferencing along with the Chief Justice. Today, we have successfully done video conferencing with victims in Bangladesh, with victims in Nepal, across Mumbai, Bangalore, Kolkata, Delhi. But let's take it out there. Let's make it an everyday occurrence. And if that happens, then we can see the system change. But victims don't have to stay locked up in a remand home for years on end. They can go back home and still testify. Our challenge has been pendency in the system. Our challenge has been inefficient evidence gathering. But there are solutions, and we're working with them. Today, while talking to the IG training in Telangana, we're looking at e-learning modules now, no longer just physical trainings. Let all police officers be trained. Issue them certificates. Look at capacity building in a whole different forum. And these are some of the solutions that we have to address this criminal justice system that is lagging behind, and criminal networks are 2 steps ahead all the while. Hopefully, UNODC will release an SOP, not very, in a couple of months perhaps, for first responders across different countries. And that's primarily because criminal networks know no boundaries. And if we are going to take them down in a network, it has to be taking down a network across different countries. And that's what we're doing. Yesterday, I made a statement where I said the DG of the BSF, Mr. KK Sharma, is very keen on addressing this, and he's ready to work with his counterparts to pick up criminal networks that are rampaging across the border. Yesterday, one of my colleagues, Mr. Ravikant, was here, and he's been using technology to generate a database of criminals. If a database like that comes into play, then where would those criminals hide? Because any lawyer that's taking it up would immediately have access to information about those criminals. Be able to use earlier FIRs, be able to use earlier judgments or convictions in the trials at present. So bails become a challenge for criminals. In several different states across the country, announcements have been made about mobile forensic vans. Mobile forensic vans are possible solutions to address the issue of gathering effective evidence. To address solutions where victims don't have to travel long distances. Perhaps this is something we could be using far more effectively in the long run, on the short run. But definitely something that we should be looking at. It's been a privilege to work with the team at Justice and Care for me. because we've been able to do some pretty innovative work with criminal trials, from video conferencing to getting possibly the single largest conviction in this country, where 39 individuals have been convicted of a sex trafficking case and 96 lakhs as fines gathered from them. It's no longer that area where criminal networks can get away with things, when there are a bunch of dedicated people from different walks of life coming together to be able to challenge the system. It's our endeavor, therefore, as lawyers and people from the legal fraternity, to be able to advance that criminal justice system, to encounter, to tackle head-on challenges that come our way. I'd like to end with a big thank you again to the sisters at Mary Ward and for you, for being patient with me and paying attention so rapidly to the presentation I have. Thank you very much.
Thank you so much, Adrian, for talking about a theme which is really relevant today, which is how does technology come into the play and what are we doing in the criminal justice system with updating ourselves with such technology. And it's a burgeoning field, I might say. And thank you so much for starting off the session so brilliantly. We move over to our next speaker, Mr. Shubhi Roy. May I request him to come to the stage? And it's around 12 minutes of speaking time. Thank you.
Thank you, Kolkata Mary Ward, for inviting me in this session to speak about my experience in the field. I'll mostly speak on the issues the victims face as a challenges while they are being called in the court for deposition. My previous speaker spoke about pendency of cases. Yes, of course, it is a big challenge, and I would like to speak why these pendencies are cases. I will mention facts. As far as NCRB data, the POXO cases in 2014, 95% cases have been pending in the court. 15, 90% cases are being pending in the court. So why I am mentioning this data? Because sizable number of traffic victims are also POXO victims. In 2016, there was an analysis and it shows the national average is 9% only the cases were heard. Now I am coming to the challenges they are being faced in the field. Because I am facilitating the victims to be deposed in the court, so I'll speak more about the ground realities. First of all, at the end of 2 years or 1.5 years, they are being called in the court, but hardly the courts are providing them expenses. From West Bengal, they are being called to Delhi. In Delhi, there are cases where the victims are getting the traveling expenses and all, but in other states, I hardly find they are being given such type of expenses, and also it becomes very much difficult for them to go back after 1.5 years because their poverty compels them not to go there. The role of NGO should be very proactive. They should be in touch with them. The second point is accommodation. And as far as accommodation is concerned, I would proudly mention the government of West Bengal has done a wonderful thing. There is a government notification that if any police officer or victim's family are going to Delhi for any ghost deposition, they will get accommodation in Bongo Bhavan. So I don't know how many of you are knowing this. I will request all of you to take the advantage of it. And I would like to say one more thing. There was a case in which the victim was somehow she was told to say her age as adult. Somewhere the system was connived and all, and ultimately the real fact came out. Then a perjury case was given against her. So now the victim case is being tried in the court, and she has become now the accused. So this is very shocking case, if I say. Then threat to victims. There are a lot of cases, whenever they get any summons, I don't know how come the destination traffickers come to know that the court has served a summon. How come? Because the trafficking is an organized crime, and everybody is come to know that yes, the court has issued the summon, and at the same time, the victim is being threatened in the villages, and there is no victim protection protocol as of now. So I would like to request the panel, whenever they will panel and the Maryland organization, they should recommend for the same. There should be a victim protection protocol in future. There is no witness protection protocol as well, and most importantly, the time tracking process in the code. Importantly, I personally saw one case in which a girl from Sunarpur area, she was called in the court 5 times. In the first day, the court was closed somehow, the court was strike, but she was not informed that court is closed. Long way from Sunarpur, she went to Delhi, and the court was closed. In the second day, there was strike from the advocates panel. So there was no advocate in the court. The cases were not heard. In the third day, what happened? The defense advocate did not turn up. So this is also a strategy from the defense. Sometimes to make the cases delay so that victim will get fed up. They will not turn up in the courts. Then the case will fall down. So gradually, she had to go 5 times in the court, and it was a big challenge for the victims. And in that circumstances, if you do not provide moral support to the victim, it will become very difficult. And this is one of the major reason why cases are being getting acquitted. One more reason: sometimes summons are not being served properly. The victims, there are a lot many reasons. Sometimes victims are not being traced. There are some connivance. The people who bring the summons, he just report to the court, the victim is not being traced, family has not been traced. So this is one of the reason. In case of victim compensation, there are some judgments in which the court has already directed the DLSA to provide the compensation. Victim somehow she did not turn up in the DLSA, and the matter is still pending in the court. So I think the government should take on their own motion, since court has already directed and DLSA is not taking anything. And investigation from the law enforcement agencies is hardly connect source, transit and destination. So whenever we rescue girls from the brothels in Delhi, the Delhi police only arrest the brothel keepers, brothel managers and all. They hardly come to the source to find out the original trafficker in the transit who was there involved. So this is not happening. And in my case, one day I was in the court for a witness, and the defense said he is the stock witness of the police. So they claimed I myself as a stock witness. So the judges argued both the teams argued the matter. Ultimately, I witnessed, but this is again one of the strategy of the defense to take all this in the court to get the cases acquitted. Now, I would like to some good responses from the court to mention here. There was a case in Bhaktinagar police station in Jalpaiguri. So on 6th May, 3 girls were rescued. All of them are major girls. They are adults. So on 7th in the court, the judge said there is shortage of judges. So the 164 statement will be taken on 17th. They are rescued on 6th, and he is saying the 164 will be taken on 17th. And in Jalpaiguri there was no home, so that they would be given shelter and all. So we spoke to the DM of Jalpaiguri, and through her intervention, the things happened on 7th only. So the judge took his order back, and he passed a new order, and 164 was taken on that particular day only. Why I am sharing this experience? I think the NGO personnel who are working in this matter, or police officials, they can take these as an example, and in future they can follow up all these cases. Sensitivity of judges is also very much important. In one such case happens, every time the police officers comes to her place to serve the summon, she gets socially discriminated. The village people say, every time police is coming, what happens and all. One day she called me and said, please give me the contact number of the judge, I will speak to her. The girl said, so what I did, I gave the contact number of the clerk, one of the clerks, and the judge was so sensitive. Her name is Kaveri Babajan, Tisajari Court, Delhi. To call in between 10 to, in office time. So judge herself listened her voice over the phone, and she directed the police. From this number the call has come, go and take the girl to the court. The next day, the police in the morning came to Kolkata. The girl is basically from North 24 Pargana. She was taken on the same day and she was taken back to West Bengal in the evening. Convicted and 10 years punishment was there in this case, and sealing of brothel was also there. And now this is the positive responses I really appreciate. And I would like to read a paragraph from a judgment. I don't find this paragraph is very sensitive, or this is session case number 44/13, State versus Sunil Sharma in Delhi. And in the judgment, the judge said it would be pertinent to mention that a recent trend is surfacing where either a domestic maid is underpaid or where she has been detained by the employer for an unusually long period. Work is unsatisfactory that such a domestic worker unfortunately resorted to invoke the laws relating to sexual abuse for achieving their goals. So the judge is saying when they are not getting their salary, when they are underpaid, when they are detained somewhere, they make allegations of sexual allegations against the employer. This is the statement from a judgment. So I personally don't support this judgment, and she repeated these statements in 10-15 judgments. Only I went through all the judgments so far, and this is a fast track court. So why I'm raising these points, we should be very much alert in the field so that more of the cases get convicted. This is my request to you. I live in Delhi. If anybody you need any help from my side, I'm always happy to extend my hands. Thank you so much.
Thank you so much, Mr. Roy. From Adrian's talk on technology and criminal networks, we've really moved to cases on the ground, and I thought there was this brilliant linkage from how technology can expedite the process, and where Mr. Roy started was the question of pendency, and then we moved on to other several issues, also major challenges, including how judicial decisions which are not so progressive also may work like precedents, and we need to be careful about that. Thank you so much for bringing us in close contact with reality and the implementation of law on the ground. We move over to our third speaker, and may I now request Aishwarya Dev to Manisha to present her session.
Good afternoon, esteemed panel members and one and all present here. Me, Manisha Manashwini, along with my co-researcher Pavitra Ravi, want to draw your attention towards the new anti-trafficking bill and the issues therein. Hence, I'll be presenting on new anti-trafficking law in India, clarifying the issues of unfinished business. To start with, I would like to quote a few words of Benjamin Franklin. Justice will not be served until those who are unaffected are as outraged as those who are. In the globalized, technologically strong global village, human trafficking is considered as a major form of organized crime and is ranked as third illicit trade, finding its mention after the top two, drugs and arms. Thus, Palermo Protocol of 2010 of United Nations came into picture. Human trafficking has clearly become modern-day slavery, being as heinous in its own way. Indian Constitution clearly prohibits traffic in human beings. Despite the facts, steps were taken to curb such practice. The report released by US on trafficking in persons in the year of 2015, India was classified as the Tier 2 nation in issues that concerns exclusively of human trafficking, it be for the purpose of sex or for the purpose of labor. Internationally, this classification clearly establishes the fact that India has not complied with the minimum standards propounded in the Trafficking Victims Protection Act. Though India has managed to move from the list of watch list nations in the year 2010, there has been no significant change since then from the category and concerns in the way the nation addresses the growing issue, and the nation being a source country, destination country, as well as a transit country for the purpose of sex and labor human trafficking. The Indian government has claimed to take serious efforts to comply with the promised minimum standards. The prevalence of law and the actions of law enforcement agencies in the given field still remain to be a quest for exploration. Given the growing menace of trafficking and ineffective laws of the nation, the Ministry of Women and Child Development has in the year of 2016 managed to unveil a new draft which would become the country's first ever comprehensive and anti-trafficking law. The draft has clearly marked its way to treat survivors as victims who are in need of assistance and protection. By prioritizing the needs of the victims, the intention was made clear that they would not be arrested and made criminals for an act that they were not responsible for. The draft also comprised a formation of special courts for expedited trials and rehabilitation homes to regenerate the victims back into society. The bill seeks to establish anti-trafficking committee at center, state and district level to check into, prevent and combat trafficking. The bill does not provide for the definition of trafficking in its true sense, and there are no time-bound measures to ensure targeted rehabilitation. Further, the bill does not for a remedy for hostile behavior that might become visible of the law enforcement agencies. Considering these issues proposed in the new draft of human trafficking, me and Pavitra wanted to draw your attention towards this issue. Continuing further, let us look at the international instruments that deal with human trafficking. International law is an important and powerful instrument for combating human trafficking. The most prominent and recent international instruments that deal in defining, preventing, and prosecuting human trafficking are the United Nations Convention Against Transnational Organized Crime and its two additional related protocols, the United Nations Protocol to Prevent, Suppress, and Punish Trafficking in Persons, and the United Nations Protocol Against the Smuggling of Migrants by Land, Sea, and Air. In support of enforcing these instruments, the United Nations Office on Drugs and Crime also established the United Nations Global Initiative to fight human trafficking in support of the above mentioned instruments. The international instruments that deal with human trafficking necessarily date back to the abolition of slavery. Thus, these instruments include provisions from the Slavery Convention of 1926, the Slave Trade and Institutions and Practices similar to slavery of 1956. Other additional instruments that also highlight certain segments against human trafficking include the Universal Declaration of Human Rights of 1948, the United Nations Convention for the Suppression of the Traffic in Persons and of the Exploitation of Prostitution of Others of 1949, the Convention of the Elimination of All Forms of Discrimination Against Women of 1979, and the International Conventions on Civil and Political Rights of 1966. The most important one is the Palermo Protocol. The Palermo Protocol aims at three things, that is, preventing and combating trafficking in persons and paying particular attention to women and children, and assisting the victims of such trafficking with full respect for their human rights, and protecting cooperation among state parties so as to meet these objectives. Now, the question remains, are the international instruments successful to combat trafficking? While the legal international norms are clear, still gaps and ambiguity exist in their implementation. Trafficking in person is a complicated issue. These legal international instruments have been initiated so as to aid the trafficking victims and also to combat this major worldwide epidemic. These issues of implementation and enforcement of anti-trafficking laws are undeniably problematic but definitely not impossible to overcome. Now, let us go through some of the past surveillance on anti-trafficking legislations in India. Anti-trafficking has been effectively prevented from times the nation realized that the system does not fit in the shape that was ever wanted for the good of the nation. Same could be traced back to the prohibition made under the Constitution of India towards anti-trafficking in human beings or persons. Taking cue from the face of the Constitution that the drafters brought in a complete legislation that would primarily prevent trafficking for the purpose of commercial sexual exploitation. In the present scenario, law has become the center of human life where it acts as a means to achieve the desired end, though not an end in itself. India is a country where the practice of sex as profession is considered as societal deviance, as it involves economic considerations and regards made only to sex and not to the social considerations, whereby value of relationships are greatly distorted. Being in a country where the profession was always considered as immoral and degrading, the legislation was keen to enact legislation where sex workers would be treated as victims, thus further demand for rehabilitation and reformation can be made. The end result of such thought process came out as the Immoral Trafficking Prevention Act of 1956. The act was implemented replacing the already existing Suppression of Immoral Traffic in Women and Girls Act 1956, which necessitated the required changes including range of sex workers and include both the genders within the term of sex work and brought men, boys, coty sex workers, etc. into the domain. The Act is that framework which in the present scenario comes in handy and proves to be an effective tool for the executives and the law enforcement agencies. The Act in itself is a self-contained code giving all the mechanisms to tackle the problem of sex work and the workers and enhance the preventive mechanisms against sex work in every nook and corner of India. India further came in the 1990s came with 3 proposals to regulate sex work and required to repeal the existing Immoral Traffic Prevention Act with the Workers Bill, the Empowerment Bill, and the proposal that was forwarded by the Center for Feminist Legal Research. The Sexual Workers and the Empowerment Bill aimed at bringing the protection to the brothel-based sex workers by prescribing enhancement and much needed protection under the labor laws recognizing the sex as a work. However, these bills have not come into force and the Immoral Traffic Prevention Act still holds good in its position. Still, it variably embraces prohibition of sex work and emphasis on the rehabilitation and reformation of the sex work. India has a growing architecture of anti-trafficking laws put in place at different points in time to address the various manifestations of extreme labor exploitation. The code already dealt with kidnapping, abduction, slavery, buying and selling minors for prostitutions, and unlawful compulsory labor. In 2013, new offences of trafficking were added, sections like 370, 370A. However, the IPC does not define slavery, bondage, forced labor, or beggar, who is a person who is forced to work against his will without payment. Labor law prohibits and penalizes existing and future bonded labor. All bonded levels are set free their obligation to repay the debt extinguished. Sure. So we will be now moving on to the issues lying in the new anti-trafficking bill. With an estimation for over 40 million modern slaves, and with the figures of 18 million from India, India has been ranked 4th of 169 nations and have been remarked as one of the primary source, transit and destination of human trafficking. Issues at focus and the attention of the majority nation being turned onto the issue, the Ministry of Women and Child Development proposed the new anti-trafficking bill in 2016. The bill has adopted the usual method of raid rescue rehabilitation and has majority of its portion emphasized on sex work, therefore making it questionable as to its ability to meet its fundamental objective. The salient features of the new bill are its efforts to create district and state anti-trafficking committees with government officers and NGO representatives. The committee would attempt to prevent, rescue, protect, and rehabilitate victims of trafficking. The committee would provide medical care, psychological assistance, and skill developments. The bill recreates new offenses. It criminalizes using a narcotic substance, alcohol, or psychotropic substance for trafficking under Section 16, administering any chemical substance or hormone to a trafficked woman or child to enable early sexual maturity under Section 17, and revealing the identity of a victim or witness to a crime of trafficking. If such information is published in the media, the offending individual, be it any individual or the media house, would be liable for punishment. It also penalizes the contravention of the registration requirements for protection homes, special homes, and placement agencies. Effectively, the new bill proposes a separate criminal law on trafficking. The District Trafficking Committee is the first port of call where a range of social actors, governmental and otherwise, must report a victim. It is unclear which agency undertakes the raid and rescue, but the victim is housed at a protection home, the police investigates the crime, and the special public prosecutor initiates prosecution in a special court. Indian legal system has historically been unable to meaningfully translate the law into action. The raid rescue rehabilitation model built into the Immoral Trafficking Prevention Act has similarly been a failure. Protective homes under the same act have perversely resulted in the state officials sexually abusing women and collusion. Thus, the government must revisit the predicament of lakhs of Indian migrant laborers who have for decades faced precarious working conditions. It must consider the plight of lakhs of workers toiling within the globally supply chains of Western corporations that manufacture in India through elaborate subcontracting arrangements. The government needs to pause and dig deep into its own long and complex legal history, as well as its unique provision of dealing with extreme exploitation that is understood today under the conceptual umbrella of trafficking. To conclude, I would just like to say that, considering the past laws that came not to solve the problems, India was in a need of comprehensive and effective anti-trafficking law that consolidates varied streams of anti-trafficking laws and also the visions of varied nations and the thousands of trafficked vulnerable sessions. The bill was a clear effort to bring in regulatory means to address the underlying issues, but unfortunately, somewhere from the legislation to the dawn of it, the legislation failed to consolidate. Hence, before the bill actually undergoes the passage and becomes law to be further amended, necessary changes could be made before in hand and to avoid further disruptions. Thank you for your patience.
Thank you, Manisha, for a comprehensive coverage of the international conventions and the domestic legislations, and perhaps looking at the problems therein. We go over to the next speaker, Aishwarya Dev, and may I now request Aishwarya to take over. And you'll get a 1 minute notes coming up. So, yeah.
A very good afternoon to everyone present here. As a student of law, I was privileged to work with Justice Dilip Kumar Basu at Legal Aid Services West Bengal extensively on the issue of human trafficking. And that was the very first time I did an extensive study on child trafficking. So today I'll be dealing with the issue of child trafficking and will be analyzing the existing legislations and also highlighting the need for a victim-centered approach. But before we move on to the topic, we need to find out what exactly is the problem zone. With the recent reports of the Ministry of Women and Child Development, which showed almost 20,000 women and children as victims of human trafficking in India, it becomes legitimate for us to question the efficacy of the legislations dealing with trafficking. Secondly, lack of uniformity with respect to definition of the term child, which thereby leads to discrimination against some children's right to protection. Thirdly, the Immoral Traffic Prevention Act 1956 has failed to provide an exclusive definition of the term trafficking in persons and only attempts to deal with trafficking for purpose of prostitution. And finally, lack of preventive mechanism and need for a victim-centered approach. Because we're dealing with the issue of child trafficking, we need to understand what does this term actually mean? Who is actually a child? The definition of child is every human being below the age of 18 years as per the UN Convention on the Rights of Child 1989. This definition has actually been followed by three primary legislations in our country, that is Protection of Children from Sexual Offences Act 2012, Juvenile Justice Care and Protection Act 2015, and the National Policy for Children 2013. However, there are certain legislations which actually provide for an alternate definition also. For example, the Child and Adolescent Labour Prohibition and Regulation Act 1986, the Right of Children to Free and Compulsory Education 2009, and obviously the Immoral Traffic Prevention Act 1956, which is actually a special legislation dealing with the problem of trafficking in persons, which has actually defined the term child as a person who has not completed the age of 16 years. In such a scenario, there are certain children who are actually deprived of the care and protection that they actually need from the legal institutions. Moving ahead, when we come to the definition of the term trafficking in persons, as per the protocol to prevent, suppress and punish trafficking in persons, especially women and children, which is also known as the trafficking protocol, the word trafficking in person includes prostitution of others or other forms of sexual exploitation, forced labor or services, slavery or practices similar to slavery, servitude or the removal of organs. However, the primary legislation in India, that is the Immoral Traffic Prevention Act, only focuses on the concept of prostitution and does not deal with the other issues like slavery, servitude, organ trafficking, etc. The term, however, has been to a certain extent followed after the 2013 Criminal Law Amendment Act and has been defined under Section 370 of Indian Penal Code 1860. Moving ahead, analyzing the primary causative factors of child trafficking like poverty, lack of opportunities for education, patriarchal culture, natural disasters and lack of awareness about trafficking, demand for cheap labor. We have already learnt about all this in the previous sessions yesterday, but the question is, does the special legislation dealing with in our country actually address these issues? Is it actually a preventive mechanism or does it only act in a reactive way? The Immoral Traffic Prevention Act does not address any of the issues, rather it only focuses on punishment. Moving ahead, we are now going to critically analyze the Immoral Traffic Prevention Act 1956. The intent of the legislation has majorly been to inhibit or abolish commercialized vice, namely trafficking for the purpose of prostitution. Not consider prostitution as an offense in itself, but penalizes other activities, for instance, maintaining a brothel, detaining a person in a brothel, and so on and so forth. The statute has failed to provide any definition of the term, as we have already seen. The statute does not consider it necessary to address certain anti-trafficking measures that can be unique to only children. Obviously, the measures that we can apply in case of elderly women or other people does not obviously apply for children. Parents also play a major role in the trafficking of their own children, maybe to the third parties. But the statute has also failed to deal with this issue effectively. There is a notion that obviously parents always look after the children. They are the ones who care for the children. Also, as per the United Nations Conventions for the Rights of the Child, a person should always be put in the best care possible. And I think in today's scenario, it's a myth that only parents are capable of giving that sort of a protection to the children, because we see parents are basically selling the children when they are in need of money. So parents actually play a very proactive role in selling off their children or forcing their children to go into various kind of illegal activities, etc. The legislation as well the executive has failed to draw a well thought out plan for rehabilitation of the rescued children in the society. What happens is that many a times the children who are actually being rescued, they are not even seen as victims. If a children is actually rescued from a brothel, and especially the children of the prostitutes or the sex workers, since these women are actually termed as fallen women, their children are also being looked down upon, and so they don't get a parity in status with other children. Even if you send these children to schools, other children look down upon them. So there are certain issues which have to be considered. There were two bills that were tabled in the houses of the parliament. That is the Immoral Traffic Prevention Amendment Bill 2006, which actually asked for the establishment of authority to combat trafficking in persons, which is not yet established. And moving on, there was another bill, that is a bill of 2013, which also proposed the definition of trafficking in persons in accordance with the Trafficking Protocol. Now there is another legislation, that's the JJ Act 2015. It has actually repealed the JJ Act 2013 after the Nirbhaya case. This is the act which is right now in action. But what is the base? So this act also prohibits the use of children for begging, vending, peddling, or smuggling of drugs and psychotropic substances. Even though the act considers a trafficked child to be vulnerable and in need of care and protection, but it makes no further intervention specific to trafficking. For example, there is a provision to setting up of protective homes and shelter homes, but there have been various reports where we have seen that the children who have been placed in the shelter homes are being sexually exploited by the caregivers, the so-called caregivers in those shelter homes, as per the report of Childline 1908. Moving forth, the Protection of Children from Sexual Offences Act 2012 is a very new legislation which specifically deals with the offense of child sexual abuse, which is actually a very important part of this offense of child trafficking, and has imposed a lot of strong deterrent punishment for that kind of crimes. The Supreme Court of India has actually played a very proactive role in being the protector of human rights, that is also the child rights. Starting from the case of Vishaljeet versus Union of India, the approach of judiciary has changed with time, and in the very recent case of exploitation of children in orphanages, the Supreme Court of India has specifically directed the state governments and the union territories to set up homes and to impose certain directions so that the children who are actually placed there the caregivers can actually be the caregivers and secure the best interest of the child in accordance with the Convention of the Child Rights. Finally, the need of victim-centered approach can be highlighted. The trafficked person must be recognized as a victim who is entitled to basic human rights, including the right to be heard in the court of law. In the form of initial disclosure of exploitation is usually the starting point of investigation, and in the form of evidence he or she gives at the trial is also the foundation of a case. What is therefore required is minimizing the impact of the investigation and also minimizing the trauma of testifying, making child-friendly provisions whereby medical examination of a victim should not be a prerequisite for victim intake or admission into a shelter home, and no child victim should be denied immediate shelter on such grounds. The state should also act in the capacity of parents patriae, that is like a parent, and ensure that the child should be able to access legal assistance throughout the criminal proceedings. We can just have a look at the series of bills that were actually tabled before the various houses of the parliament, but they have not become an act as of yet. This is the Girl Child Prevention of Trafficking and Miscellaneous Provisions Bill 2008. Moving on to the next slide, we have the Girl Child Prevention of Commercialized Trafficking, Rehabilitation and Welfare Bill 2015. Then we have the Prevention of Pushing and Forcing Girl Child into Flesh Trade and Immoral Traffic Bill 2006. Then we have the Prevention of Trafficking and Abuse of Children Bill 2009. Prevention of Trafficking of Girl Child for Commercial Purposes Bill 2011. Prevention of Trafficking of Girl Child for the Commercial Purposes Bill 2015. Commercialized Girl Child Trafficking Prevention Rehabilitation Welfare Bill 2006. The latest being the Human Trafficking Prevention Bill 2010, which actually tries to address the problem of human trafficking as a whole. And finally, I would like to conclude by saying that there's a need to amend the existing legislation in a more reactive way to bring about an entirely new legislation, which will comprise of both preventive and punitive mechanisms to mitigate the menace of child trafficking. The recent problem is that the national and regional government agencies are finding it difficult to investigate the problems, which is actually allowing the perpetrators to go away. So a comprehensive code is basically what is required. The Immoral Traffic Prevention Act has numerous pending amendments which have not been passed yet, and so those amendments should be brought forth as early as possible. What can only be expected is that now we need a new comprehensive bill which will actually address all the issues that I have stated earlier. And finally, I want to say that special courts should be established which will actually have special public prosecutors and special judges who will not have any other responsibilities and will only focus on these cases of trafficking, so that these issues can be addressed properly and they can be solved as fast as possible, because justice delayed is justice denied. Thank you.
Thank you so much, Aishwarya, for highlighting several important points. I felt one of the most important points that emerged from yours and other people's conversations. I'm sure that every time we talk about anti-trafficking legislative measures, we sort of end up talking about sex trafficking and not about other forms of trafficking. And all our interventions are also primarily the brothel-based intervention. And you have highlighted that sort of the skewed purposes of the law and intervention that we have. Thank you. Thank you for drawing our attention to prevention instead of what you call reactive legislative politics, and the problem of not having a uniform definition of the child, and whether the JJ Act will trump in a case where the child is between 16 and 18 years. Thank you for suggesting solutions, if any, and perhaps somewhere we can take off from your presentation is law the answer, because prevention will not come from the law, it will have to come from a complete socio-political shift, and how does the law fit in there, I think, is from where the paper goes from here. Thank you very much for being very comprehensive. We have our last speaker for the session, Parvati. Thank you for waiting so patiently, and Parvati's talk.
A very good afternoon, everyone. So, yeah, so I'm here to talk about combating human trafficking, especially legal responses and its challenges. Abraham Lincoln rightly said, slavery is founded in the selfishness of man's nature, and opposition to it is his love of justice. And we are here to talk about the most modern form of slavery, that is human trafficking. So, we know human trafficking is a grave violation of human rights. It is the second largest commercial enterprise which is affecting in the global scenario. And the first question is, why do people fall, or how a person is becoming a victim of trafficking? There are different social, political, economical, and cultural factors which affect. And also the people's desire to get better conditions, that to come out of poverty and better opportunities, and different factors like as panelists mentioned before, like economic factors, environmental factors, and everything affects a person into like uh, the person becomes a victim. And we know different, no, like when we discuss about human trafficking, it's not only commercial sexual exploitation. Beyond that, there is forced labor and also debt bondage. It's also exploitation. And, and in this paper, I'll be mainly discussing about the existing legal provisions and whether all these laws are effective, and also the challenges and address measures. And in the global scenario, the Universal Declaration of Human Rights, the International Covenants on Civil and Political Rights, the United Nations Conventions for the Suppression of Trafficking in Person and of Exploitation of the Prostitution of Others, and the Conventions on the Elimination of all forms of discrimination against women. Laws form the basic structure in the international law against human trafficking. And we know United Nations, it acts as a major organization to fighting against human trafficking, and it has made several conventions against trans organized crime, and it came up with three protocols: the protocol to prevent, suppress, and punish trafficking in person, especially women and children, and the protocol against the smuggling of migrants by land, sea, and air, and the protocol against illicit manufacturing and trafficking in arms. And another important protocol is the optional protocol on the sale of children, child prostitution, and child pornography. And beyond, when we consider about forced labor and child labor, the International Labour Organization, which play major roles in like preventing forced labor, and it also came up with many conventions. United Nations Global Initiative to Fight Against Human Trafficking, and its main objective is to promote global fight against trafficking in persons on the basis of international agreements reached the United Nations. And all these organizations, ILO and United Nations High Commissioner for Human Rights, UNICEF, and Organization for Security and Cooperation in Europe, International Organization for Migration, and United Nations Office on Drugs and Crime. And all these organizations work together to prevent, it's act as a global initiative against human trafficking. Regional legislations are also there in United States, Europe, and also commits a sub-regional group initiative of China, Laos, Thailand, Myanmar, Cambodia, and Vietnam. In India, we have also become a signatory of major conventions against human trafficking, and we are also a part of SARC. And when we come to India, we know we have Indian Penal Code, which is the major criminal code of our country, and under IPC sections 359 to 374. It deals with different issues which comes under human trafficking or which is the violation of human rights. Legislations, various legislations we have against human trafficking, against commercial sexual exploitation, forced labor, child labor, etc. So all these bonded labor system abolition act, scheduled caste and scheduled tribe prevention act, protection of civil rights act, and the juvenile justice care and protection act, the protection of children from sexual offense act, and which is like most every day when we read the newspaper, there will be a case which is from POSCO Act. So it's a very sad thing which we should accept. And when we consider women, to protect the dignity of a woman, we have two acts like the Immoral Traffic Prevention Act and the Suppression of Immoral Trafficking Traffic in Women and Girls Act 1957. And when we see all these data, we should think how effective all these laws are. And also we have Criminal Law Amendment Act of 2013 and Transplantation of Human Organ Act 1994. And Transplantation of Human Organ Act is a major act to prevent organ organ trafficking, which is also becoming a major issue which we are facing. India judiciary or judicial activism, which plays a major role, and these are the major judicial pronouncements like Prerna versus Union of India, Prajwala versus Union of India, and these two are NGOs. When NGOs actively participate in the judicial activism, and these two case laws, which were public interest litigation to protect women from human rights, and it's a part of anti-human trafficking initiative. And also Gaurav Jain versus Union of India. In that case, we know there was a very important decisions which the court made that there should be commissions to protect the rights. And when we discuss about the effectiveness of law, first we will come to the ineffectiveness of laws. We know IPC is in a narrow scope, and it is less capable to deal with many problems. That too, all the issues which women or children facing today, which doesn't comes under the provisions of kidnapping or abduction or what all mentioned in IPC. So that is a major challenge which we are facing with our existing laws. And Child Labor Prohibition Amendment Act 2016, which is very recent and which suffers several flaws. And the main thing is it slashed the list of hazardous occupations in which a child should not be a part, and they slashed the list or major industries which should be in the list from 83 to mere mining and other hazardous industry. And the Suppression of Immoral Trafficking Act, which has many drawbacks and which describe penalties on the basis of sex. That is, a prostitute means a woman. A woman is getting punishment for 1 year. The pimps or who actively participate in that, they are getting the fine or mere fine or a penalty and imprisonment for 3 months. And another important factor is ineffectiveness in the enforcement of all these laws. All these main stakeholders, from police officers to the judicial officers, they should try to effectively implement all these laws. And coming to the challenges in combating human trafficking, challenge that defining the crime itself that I have mentioned before, Like IPC, all the crimes or all the issues, the sins comes under the provisions of IPC. And identification of crime and its victims, it is also a major problem. And we know low number of convictions, that in the previous sessions many people have mentioned that there is very less number of convictions of all these offenses are happening. That can be because of different reasons, lack of evidence and lack of low legal provisions, etc. And we know pimping or brokering are existing as a hurdle, and accused persons' rights are denied. And when we consider the victims here, panelists have said about from the side of a victim. And when we try to enforce a law, there will be the hurdles faced by the law enforcement agencies also. Like how to prosecute without a victim, and non-cooperation of victim always affects the prosecution. And also, the trauma causes a large impact on the victim, which affects the efforts of law enforcement agencies. And also, delay in reporting the incidents due to fear of reprisals from traffickers, the political and social pressure, which also affect the law enforcement agencies. And how to combat human trafficking? We have a 4P paradigm: prevention, prosecution, protection, and partnership. Prevention, under prevention comes awareness, education, etc. And prosecution, we know proper investigation, and then protection and partnership. Partnership is the major role which we have to do through the participation of NGOs and all the stakeholders of law. Awareness, education, safe place to learn and live, psychological support, poverty alleviation, targeting vulnerable sections, and strict monitoring and administration is also a major important factor while fighting against human trafficking. So let me conclude with the quote of Abraham Lincoln: if slavery is right, all the words, acts, law, and constitution against it are themselves wrong and should be silenced and swept away. Thank you.
Thank you, Parvati, again for a very comprehensive analysis of the laws. A big thanks to all the speakers for keeping to the timeline, and so that we have a little more time for discussion. Maybe the next 15-20 minutes can be for discussions and questions and comments from the floor. Just to sort of, I don't want to summarize, I can't summarize what all the speakers said, but a few cues for thought and something that perhaps ties what all the speakers were talking. And to me, it seemed that something that emerged from the discussions in this panel and also throughout the 2 days, I think, is that something that I also said before, that there is an increasing juridification in the Indian context, which is that there are laws and there are laws, and laws that are in the phase of amendment, many shades, many drafts that go through, and then there are other processes that stall that law from being passed, etc. So there is a clear understanding that for trafficking issues, people don't know what is to be done legally. So there is an increasing juridification of the problem of trafficking, and very clearly, as we engage in pushing for more and more laws the way we want, we have also realized, and 2 of our speakers have clearly pointed in that direction, the inefficacy of the legal system. One is that the legal system is not adept to technological and other kinds of changes. The other speaker talked about how the judicial process, its length, the process itself, the way you seek evidence, etc., is pushes the women and the girls who come to depose the corridor children more and more on the margins. And our three other speakers were all of the number of laws that are there, but the inefficiency of the system to deliver justice. So that's, I think, one major thing that emerged. The second thing that perhaps emerged is, we have talked about a lot about international laws here. A question that might emerge is what impact does international conventions have on domestic arrangements, because India, being a dualist legal system, which is international law automatically doesn't become domestic law, and there is a process of legal change. The international law do for us? It's great to quote several international laws. We need to remember them, but perhaps there should be more advocacy on trying that in our judicial decisions, in our local laws, we should be looking at what the international obligations have been. And it might just be also interesting to look at how many judicial decisions, which many of our speakers were talking about, actually draw upon international obligations that India is a signatory to, at least. So, and the third point that I was thinking is that there was a brief mention of SAARC, and there is a regional arrangements. And while we know that multilateral arrangements and regional arrangements work between India and other countries when it comes to trade, because the sanctions are higher and the sanctions are stricter. When it comes to international human rights law, the sanctions are poor, weak monitoring mechanisms, and regional arrangements completely fall apart. We've seen this for many kinds of things, including political, but definitely for a thing like anti-trafficking. We know from where girls and women come in. We know that there is a bilateral agreement between India and Bangladesh, or India and Nepal. But how does it work? What do we do with the regional arrangements? Why don't we push for more and more consolidation here? Also, a point that perhaps didn't come in so strongly in this part of the panel, but this is something that I was discussing before the panel started, which is, Aishwarya did talk about that our processes are more curative than proactive. And one of the parts of rescue operations or anti-trafficking network is to enable the victim, oblique survivor, to go back from where she came in, right? Which is essentially rehabilitation and restitution and restoration, finally. How do these work in the Indian context? What happens when we rescue the girl and put her back into the same society from where she was trafficked in the first place? What is the answer if we don't want to send her back home because the home is a dangerous place? We've talked about child sexual abuse. We put her in a home. And again, there's a plethora of researches that show us what homes are. They aren't anything, childcare institutions or institutions for women are not homes. They might be safe places, also places where freedom is curbed. There are also places from where women and children run away. That's not to say that these homes don't function well. It's just that, our urge to get back to a different kind of life is very strong. How does our rehabilitation processes of taking people out of a trade that is not good for them and putting them into full employment work? We know how vocational systems work in India. It's a very, very complex web of criminality, of that Adrian was talking about. It's also a complex web of how do we look at certain things as immoral, and the law pushes towards that. And finally, I think it is the lack of social, political recognition that trafficking is an extremely important issue where only radical preventive measures can work. As much as legislative measures need to be strengthened, and there is no question, it's unquestioned that legislative measures need to be strengthened, the point is to prevent. And what do we do about that prevention? Will it happen through laws? Partially, but anyone who's worked with laws for years will say laws will only work partially. So what do we do? Do we put all our eggs in one basket, put all our energies into looking for more and more amendments? What does prevention mean? And how strong is that prevention, which is not equivalent to paternalism and protection? It's not about telling children, don't talk to that boy because he's going to run away with you and sell you off, but how, next thing, how do we do prevention, which will enable children not to elope and, for example, be trafficked. Somebody talked about POXO, but a kind of protection which is liberating and not paternalistic. Can we move towards that? I mean, a lot of us were quoting Abe Lincoln, but the point is that that was the beginning of a civil rights huge movement for change. Can we move towards that? Thank you very much for all the attention. A big thanks to all the speakers for being here and for being a grand audience. And I don't know, yes, so there is time for question answer session for about 10-15 minutes. I think we need to break by 3:15. So I open the floor. Thank you so much. I think we need another mic.
Under international law, there are 3 crimes against humanity. One is genocide, 2 is human trafficking, slavery, and third is trafficking of drugs. Therefore, it is an international crime. And now you even have the International Criminal Court of Justice in Rome. So I don't see where the problem lies. I mean, I think the problem would be how to nab the perpetrators who are, gangs operating cross-border. So even if you don't have strong enough laws within a specific country, it is an international, a peremptory normal international law. Under no civilized system, civilized state would consider human trafficking legal or a valid pastime or a valid profession. So I don't see where the problem is. It's not with the laws. It's how you implement it, how you try to track down the perpetrators. That is most important. And of course, your societal ways of functioning, where you have, you provide enough employment, you see that women are not treated more badly or not even treated as regular citizens. The disadvantaged sections like children or disabled, they all have equal rights. That should be the concern of the state. But human trafficking, there can be no 2 ways about it. It is a crime against humanity.
Yeah. Thank you very much.
And again, reiterate, even if you don't have your laws in place, you go to the International Criminal Court in Rome. I mean, genocide. A lot of countries will not like their so-called prime ministers, presidents prosecuted. I'm sure that Mr. Mugabe will possibly end up in the International Criminal Court of Justice. So it's not automatically state laws. These 3 laws are declared crimes against humanity.
Thank you, ma'am, for your important comments. Can we have short, precise questions from the floor or short, precise comments? Yes, maybe, please identify yourselves if you can, and to whom the question is directed. We might take a host of questions and then panelists can respond. Yes.
I'm ex-chairperson of CWC and now I'm Honorary General Secretary of All Bengal Women's Union, who's been working for the rights of the women and the children. My one suggestion is that we are talking about the reform and change of law and etc. But we are not concentrating on the prevention aspect. What we are thinking in West Bengal is that we have already started CPC, formation of CPC, that is Child Protection Committees in every village, in every block and in every ward of the city. What is the need of the society is now today to empower these committees so that they can look after these vulnerable children and women, and they will be the first committee to be involved in getting informations about who are the victims, who will be the potential victims, and who are in danger of being victimized. Thank you.
Any more questions, comments from the floor, please?
Namaskar, I came from Sundarban in Basanti block area. I want to say in Hindi, I see any child protection committee in the village area. मेरा बोलने का मतलब यह है कि पॉलिटिक्स या पंचायत लेवल या आपका बीडीओ का तरफ से दिखाई नहीं देगा। पेपर्स में बहुत सारा कुछ दिखाई देता है कि यहाँ पे ये चाइल्ड प्रोटेक्शन कमिटी, वहाँ पे इतना चाइल्ड प्रोटेक्शन कमिटी थी। प्रैक्टिकली देयर इज नो सीपीसी। हम लोग ट्रेनिंग अवेयरनेस प्रोग्राम करते हैं, वहाँ पे देखते हैं, लेकिन सपोज वर्ल्ड विजन या ऐसा कोई एनजीओ कुछ एक दो तो ऐसे चाइल्ड प्रोटेक्शन कमिटी बनाया है। तो मेरा क्वेश्चन है ये कि इसका मतलब क्या है? मतलब गवर्नमेंट का जो स्कीम है वो विलेज पूरा ग्रास रूट लेवल में, इसके बारे में आप लोग क्या सोच रहे हैं या क्या करना चाहिए?
We've got one question that CPCs are not being implemented. Anybody? Are there any more questions?
So good afternoon, everyone. This is Dr. Amrita from Chennai, Tamil Nadu. This is just an insight which arised out of this session, and I just want the panelists and the rest of the audience over here to shed light upon it. So apart from the judicial and the legislative responses, I think the police personnel at the local areas who are enforced and entrusted with the responsibility of protecting the victims, of preventing the event of trafficking, and also prosecuting the traffickers. So how far the police personnel are equipped with the skills and knowledge of curbing this crime? So I just want you all to shed light upon it. Thank you.
While we wait for more questions, would our panelists like to respond to the two questions? Anybody here who wants to take a question? Yeah, sure.
Sorry. I thought I'd respond to the first question to begin with. Mechanisms exist for addressing criminal offences. How they work is another question, in terms of whether they work within the state or within the country or internationally. And it needs to follow a particular process. Presently, law enforcement agencies are working together. My colleague who was sitting here for the longest time and has left now, from British High Commission, is somebody we work with very closely, where the British police are working with the Indian counterparts in West Bengal, particularly in Tamil Nadu and a few other states as well, to be able to address this issue, both across the countries. My very learned colleague, Advocate Salma Ali, has just walked in as well, and she will tell you from that end how we've been working together to address issues of trafficking, where we're picking up cases in Bangladesh and in India with the same cause of action, same offense, and places. So there are these initiatives and endeavors that are looking to address the issue of trafficking. It is far more complex when we're talking about criminal organized networks which don't have any boundaries. Where do you prosecute them? How does one move evidence across from one side to the other? Bangladesh, for instance, has a fantastic notification which allows for any DC in Bangladesh to take cognizance of an summons from any judge in India and enforce execution of the same in Bangladesh. The same does not apply in India yet. We've been trying for that, but hopefully it will happen soon enough. In India, a charge sheet needs to be filed within 60 to 90 days. In Bangladesh, it needs to be filed in 30 days. How does one therefore adjust to both the setups in order to make things happen? For the prosecutors in Bangladesh to be able to do their job effectively, they need the evidence to come in from India. If we follow the Mutual Legal Assistance Treaty, it could take all of 9 months to get across. But because of the MOU that exists presently, the RRI task forces that exist in each of the countries, it is possible, and we are working, Mr. Manavendra here as well as been working very hard to make sure a mechanism exists to transfer evidence from India to Bangladesh so that they can use that evidence there effectively for the prosecution of traffickers in that country as well. And we're looking at this across the globe. In a conversation before this began with my colleague from the British High Commission, we were talking about how we will do video conferencing for an Australian American. Australian was raped, and how the courts are recalling her, but how we'll make that work through video conferencing. So possibilities exist. How we're making use of them or how we're implementing them is something of a challenge, and we are slowly addressing that. In terms of the other two questions that came up as well, it's precisely the difference between
overrides territorial unity. But it is established it is a crime against humanity. Why not use that mechanism? That it is being done in genocide. I mean, you may have to work out the process associated. Again, maybe another convention. But you have this.
Yes, absolutely. It's possibility that we can look at. I'm sure the state, the Union of India is going to look at down the line. The earlier question, the other two questions that arose, it's a matter of what exists and how we implement it. And that's really a challenge as well. In many ways, implementation is happening on the ground, both with organizations like BBA, like ADSEC, like BNWLA, and so on. They are enforcing implementation, and there's no harm in that, in the manner in which it's being done. It's a question of the will to make it work.
Mr. Roy, you were put there, or responding to the two?
So regarding the non-functioning of CPCs and all, I would like to respond, make them accountable. Write an application, write a letter, take the receiving and go to the higher authorities. First, you should try to know what is the role of CPCs, write to them, write to videos. If video does not hear, go to the DM. Example, in 2014, I wrote an application to CWC Delhi that in this year we have produced 71 children before this committee. What is the present status of these children? Please let us know. Followed by 2 reminders. They did not respond. One day in the court literally scolded me and said, you people are rescuing children and you do not do any follow-up. I told before the court the same thing, then court told me to give in writing. I gave in writing. Then the court summoned the secretary WCD in the court, and they had no option to speak before the court. They went back to the office and they came up with a government order, and they said from now onwards the NGO involved in rescue operations will have to be updated by the CWC about the present status of the children. So we have this order now from Delhi government. I think this should be replicated in other states also.
Again, of course, not being in the panel, but I could not control because I've been working extensively with the CPCs. So, acknowledging the efforts of the state, because the state has now have its own budget for CPCs. Training programs are being held in every block, every village level, and there are members, those who are coming, they are taking it very seriously. Child clubs being formed, yes. Maybe you can say the flow is slow because there are a lot of effort which goes on, really calling them up and bringing them together. But I won't say that the state has not done anything. CPCs are happening. Yeah, thank you.
This is one more question.
Is there a question? Yeah. One last question. Yes.
So I think I'm pretty loud enough. I can
Switch the mic on, please.
We can record it.
There's more of a thought and something that I really want all of us to think about. Very recently, we've seen cases where survivors who've been victims of trafficking, the criminal networks have been too smart enough, and they are actually threatening them, making it really difficult for them, and using them for trafficking further, and they're becoming accused instead of a victim. I've been recently reading some articles in Bulgaria and Spain where there have been trafficking of women who have not only been victims, but they have now been pushed to actually steal and even hurt the customers, and they are becoming victims in those accused in those countries. So, larger issue of the response to human trafficking when the victims only don't know they are victims, but now the victims are being converted into accused. So a response would be really interesting.
We have also different. Can I respond for a second? I think we have different examples here in West Bengal itself. Yesterday we had Anwara here. She was helping the traffickers initially and was a trafficker herself. But then she changed herself and now helped in rescuing hundreds of girls from Sundarban area and South Chavez Pargana and North Chavez Pargana. So we have different examples. Can we change them? Can you be the change agents to change these traffickers as well? Traffickers also. We should not neglect them. Thank you.
Adrian wants to add. So,
I think what's pretty well known today is that trafficking networks actually use the same channels, routes, as well as the same personnel for executing different sorts of crimes. We are aware that in the north, for instance, they use the drug route to bring in arms and ammunition. We are aware that in the east here, they're using human victims of trafficking to transport IED and detonators and so on across the border, or vice versa, to use them for smuggling and so on from India to Bangladesh. So definitely that needs to be addressed. In terms of what this method of addressing or what our strategy is going to be, I believe your question is about the approach that we need to have to address this. And by understanding human trafficking within the context of organized crime, we are far better placed to be able to address the various kinds of crimes that are being committed on victims themselves, not just about sexual crimes, but everything else as well, and how we can therefore address that. Once that is something that we can put in place, then automatically addressing what would be otherwise considered a crime of victim becomes ordinarily taken care of. What was a crime for victims earlier is no longer one today in terms of Section 8 of the Immoral Trafficking Prevention Act. And that has been now shoved, it's been dealt with through government notifications and so on, and hopefully the bill will remove that altogether. But that's one way of addressing it. Another is in the implementation or action itself. Unfortunately, plea bargaining doesn't work, or otherwise we might have looked at turning victims like these who have been accused into approvers. And then we can see how we can maybe turn that around as well.
Thank you. The three other speakers have not responded, so is anything that three other speakers want to add on to the question or to your talk in general, and then we can wrap up.
I would just like to say that social acceptance also plays a very big role because at times we can see that the traffickers were once the victims of trafficking themselves, and even if they want to change themselves, they always have this fear: will the society accept me? Will the society treat me as a criminal, or will they treat me as a victim? So the point is, there might be a minor or a child who was once a victim of trafficking, but now he has been given the job to traffic other people. So will that child be actually treated as a juvenile in conflict with law, or he will be treated as a child in need of care and protection? That is something to think about. How will the society treat him, even if he tries to change himself? That is something that he might always think, that even if I try to change myself, will the society treat me as a normal person, or will he treat me like any other offender?
Very good.
Thank you. Um, with that, we close this session. Thank you to all the panelists here, and a big thanks to the audience. Thank you very much.
So, thank you all the panelists here and the moderator also. So, I'm having a thought in my mind which I would like to share, that being working in the field extensively, um, I have seen a boy. I have seen a boy who works in a hotel, and when I go and ask him that, is this your hotel? He just stays quiet to it, just to investigate that whether, because they say it's my father's hotel, I'm just spending few hours here. And then I ask him, what is your age? He just murmurs something which I can't hear. And then, how long have you been working? He just turns away his face and walks. Again asking, he tells me, I am 19. He doesn't look like.
Because he was told to say that.
He doesn't look like. I have seen a girl who has been complaining in some, when I was working in some part of Sundarbans. She told, I am being abused by my uncle at home. But I asked her that, have you reported? Is it? Do I have to report anybody? So should I be happy that my boy knows the law? Or should I lament upon that my girl doesn't know the law? So this is the stage where my society is, my community is. The boy knows the law, so he's safeguarding, and the poor girl, she doesn't know the law, that's why she's just shutting her mouth. So we need to have a real breakthrough. The law is important, everybody should know, but to, to be a voice for themselves and for others. I'd like to thank each one of us who have given us great insights. And as we felicitate, I would request Navnita to come and felicitate our moderator, Ruchira Goswami. I would like to invite Mr. Adrian Philip and Navnita, kindly felicitate him. Miss Manisha, can you please come? I would request Mr. Subir Roy to please come upon, and Avanita, please kindly facilitate. Ms. Aishwarya Dev. Ms. Parvati. Thank you all participants. It was I believe it was a healthy interaction and a fruitful knowledge session. I would also request you all to kindly join your hands and thank the staffs who have been working hard to make this conference a successful one. Thank you. So can we move to the auditorium for the closing ceremony? Thank you.